Hello, I'm Jennifer Airy with the Jewish Federation of Southern New Jersey. I'm the Special Needs Navigator, and I'd like to welcome everyone to our first video installment of JAA Your Way. And I'm here today with Diana Seaver. She is a school law attorney with the law firm of Pasternak Apel in Morristown. Welcome, Diana.
Thank you, Jennifer.
Oh, thanks. So tell us a little bit about yourself and how you got involved with the special needs community.
Well, I have been an attorney for about over 25 years, and I'm also the mother of a special needs child. So from birth, I've been his best advocate, and I decided to take my knowledge and help other people along the way.
Wonderful. And you're going to be here talking with us today about school law and the ABCs of IEPs.
In the special education law, there are a lot of acronyms that are thrown around, and practitioners throw those words around or those acronyms around, but the local parents or just lay people don't know what those really mean. So we're here to really go through and explain what all those fancy initials mean.
Okay, great, because I know for myself, I have two children. Both of them are, receive special education services at their school district. And sometimes I'm sitting there at those meetings and I'm like, what are you talking about? It's so confusing.
Exactly. The acronyms stand for very long words, and so it is commonplace for practitioners to use those initials just to streamline the conversation. And sometimes the parties to the programs forget that not everybody in the room knows what those initials mean.
Right.
So hopefully we'll be able to help everyone here today navigate what those things mean.
Right, definitely. Now, for me, my understanding is that kind of everything with special education starts with the IDEA.
Sure. The IDEA is a federal funding statute. It's called the Individuals with Disabilities in Education Act.
Okay.
And basically it is the federal statute that oversees the eligibility for students entitled to special education and related services in their education.
Okay, so it's what gives us the right to get like modifications and things and services that our children need in the schools. That's kind of where everything starts with the IDEA.
It is where everything starts. If your child is deemed eligible for special education and related services within the meaning of the IDEA, then the statute outlines or prescribes guidelines and things that the school district has to do in terms of how that child presents.
Okay, so now, there's things that the school district has to do. There's a process that has to be followed. What does that look like?
There is a whole process that has to be followed, and it starts with, does the IDEA apply to your student?
Okay.
And the IDEA will apply to your student if your student is considered a qualified student for a disability within the meaning of the statute.
Okay.
And then those words aren't just words, they're actually definitions in the statute that need to be met in order for services to flow.
Okay, great. Now, I know there's some other laws that come into play and some other acronyms sort of at the high level with the IDEA. I've heard of something called FAPE, but I've never had anybody like really explain that to me. Can you tell me what that is?
Sure. FAPE is once your child or your student is determined to be a student, a disabled student within the meaning of the IDEA, then that entitles them to what's called FAPE in the LRE.
Okay.
FAPE is free and appropriate education, and LRE is in the least restrictive environment.
Okay.
And so what that means is every child in public education is entitled to a free and appropriate education. The question is, what does that look like for a student with special needs? And what has been determined is that a free and appropriate education is designed to provide the student with some meaningful benefit.
Okay.
So regardless of the disability with which the student presents, each student should be able to make meaningful progress within the background of what their struggles may be.
Okay.
So in other words, there should always be goals, there should always be objectives, and there should always be progress.
Right.
What progress for for one student may look a lot different
Absolutely.
than progress for another, but everyone is entitled to make progress.
Right.
That progress is going to look different based on the student, which
Right.
is really exactly how life is,
Right.
because every student is different.
Yeah, you have some
So-
kids that are good in math, some that are better in English, and it just really depends on the child and what their strengths are.
Right.
Okay.
It is a way, I think, to allow everyone to revisit and understand that the special education child, or the child who's receiving special education and related services,
Right.
is still entitled to make progress.
Okay.
And sometimes I think people need a little reminding of that.
Yeah, absolutely, absolutely. Now, least restrictive environment, I'm just curious, is that where a lot of the effort for more of an inclusive classroom, is that where that's sort of originating from?
Absolutely.
Okay.
Absolutely. Least restrictive environment recognizes that the overall goal is to educate all children in the general education setting as much as possible, to the extent that the child's difficulties or struggles
Right.
will allow. Sometimes that's not always the case, but the general rule is if everyone can be educated in a general education setting, then let's do that. General education setting meaning the traditional classroom. And if there are supports that need to be put in place,
Right.
if those supports can be introduced into the regular education classroom, then that is the goal of the IDEA.
Okay, great. Now, for myself, I have 2 sons with autism, so I've been through the school process of getting them, getting all these laws and services and all that kind of coming into play for them. But what I remember from the process was we had like 2 options, and it all depended on what my sons qualified for. One was something called an IEP, and the other is something called a 504 plan. And both of my boys have actually had both. We started with a 504 plan and then moved into an IEP. Can you tell us more about what each of those are and what makes them, different in their strengths kind of for both?
Sure. Under the IDEA, the IDEA, like I said, is the statute that oversees special education and related services.
Okay.
And so the IDEA is the guide, and the IEP is really the roadmap to get there, and how those special education and related services are implemented. In order to qualify and to get an IEP put in place, you need to be a qualified student with a disability. That disability needs to adversely affect their educational performance, and the student is in need of special education and related services.
Okay, so if the student, I'm trying to understand this. So if, like, for my son, if he's in class, say for like his language arts class, and he's really struggling maybe with like forming the words on his spelling test, and he's struggling with some of the other things, he would have a really hard time like taking the ideas in his head and like putting them onto the paper. There was something in that process that was really hard for him. And the school said, we recognize that this is a problem, so they provided him a scribe. So this was somebody he would dictate to, and then they would write for him. Is that an example of some of these accommodations that they can do?
Absolutely.
Okay.
And the difference is between, and back to your question about what's the difference between an IEP and a 504, the IEP, the easiest thing to remember with an IEP is if there's an adverse educational impact and the child needs special education, meaning specialized instruction and related services, then an IEP is the more appropriate vehicle to obtain those supports and accommodations. If the child does not have an adverse educational impact, but perhaps needs modifications to the environment, modifications to the layout of the school, needs to use the elevator, needs a service dog, those types of examples, then a 504 is the more appropriate plan, because the 504 is not tied to educational performance, whereas an IEP is.
Right, so the 504 so then thinking about your examples there, so if a child needed a break so that they could, get a snack if like they had low blood sugar or something like that, something that isn't directly related to like their ability to learn something or their ability to express themselves like on tests or in the curriculum.
Correct.
Okay.
For example, if a child may needs extra time or because they have some occupational therapy limitations
Okay.
to handwriting. Extra time, is, as an example, is not altering the curriculum or the
Okay.
amount of curriculum the child is expected to learn. It is just modifying the time within which the child
Right.
needs to produce what he or she has learned.
Okay.
And in that instance, there's no educational impact or adverse educational impact. It's just an accommodation to the environment.
Okay.
And therefore, the decision would be made, well, this student doesn't really present with an adverse educational impact. It's not affecting his or her ability to learn.
Okay.
It's just he or she might need some accommodations to the overall structure.
Okay, I think I get it now. So for an example that I'm thinking of is I have a friend whose daughter has diabetes. She's actually insulin dependent. And so it would be appropriate then in her case, she wouldn't have an IEP, she would have a 504 to have the breaks that she needed to go get a snack and to, you know, maybe go down to the nurse's office and get her blood levels checked. Things like that would be able to be taken care of under a 504.
They could be taken, actually, depending on the school district, they would be taken typically under a 504. Some school districts roll those into a health service plan,
Okay.
and they address it that way.
Okay.
But yes, because there's no need for a special education teacher to deliver
Right.
that content in a way that is different or modified from the way in which
Okay.
the content is delivered to the rest of the class.
Right.
So therefore, it would just be a more traditionally covered under a 504.
Okay, so I think that makes sense. Yeah. So then when my children went from their 504, they went to, because they had to have testing done. And that was a huge part of determining which one they would get, would be a 504 or an IEP. And because of the testing, then they were able to qualify for an IEP. And my son, like one thing my son would get would be social skills. He'd have a social skills class during like his lunch.
Sure.
And he would also be able to like take breaks during the middle of a test or things because he had some behavior issues. Things like that were all able to be better accommodated. Is that?
Well, probably what I'm hearing you say is that based on the testing that was done, there was a demonstration that his qualified disabilities were impeding his ability to learn in some way. So there was some adverse educational impact based on that testing.
Okay.
And because of that, some of the things that were implemented, such as extra time, are related service. But some of the other items that you've discussed is because there was an adverse educational impact.
Okay. So once the school has either identified that this child may be a candidate, or there's some adverse impact that they're seeing, or maybe the parent sees and the school doesn't necessarily see, what's the process that's used? Because I know there's testing involved and there's steps. What's the process that's used to determine whether they get a 504 or an IEP? How does that all work?
Sure. So as a parent, if you are concerned that your child is struggling in some way, it is your right to contact the school.
Okay.
And preferably in writing, in order for certain time frames to trigger.
Okay.
That I think my child is struggling in some way and I would like my child to be evaluated.
Okay.
That's step number one.
Okay.
You're not the only person. The parent isn't the only person who has the right to do that. The school districts have an obligation under IDEA, which is called child find. So technically, if there are staff members who suspect that a child may be a student with a qualified disability, then they can also initiate the referral process.
Okay. What if the parent doesn't want that process started? Can the school still do it?
No. They at an initial referral stage, so the very first time the student is being presented as potentially being a student with a disability, if the parent refuses or does not consent to testing, then the process doesn't start. There's some significance there, which is if the parents don't consent to testing, then later on the district cannot be found to have violated the IDEA by failing to provide services because the parent did not consent. At every step of the way, there must be parental consent for testing. That's a very important point to make. And certainly it makes sense, because as a parent, I don't think you'd want your child subjected to testing without your knowledge or consent.
Right.
So without parental consent, the process doesn't get started.
Okay, that makes sense. Now, for that testing, and what does that look like? What are some of the things that they're looking for, and what kind of tests do they do?
Sure. So at the initial referral stage, and again, we're talking about the very first time the student is suspected to be a child with a disability. Once the initial referral is made, whether that referral came from the parent who made a written request for evaluation, or whether the initial referral came from within the district by way of child find, within 20 days of that initial referral, there will be a meeting with what's called in the team, and this team involves parents. So parents are always part of the team that is deciding whether the student is a child with a disability, and what, if anything, can be done to support that child in the educational setting. At that initial meeting, there are a number of people that have to be there. A child study team member, somebody familiar within the district as to what those special services provisions are, who's knowledgeable about what services the district provides.
So could that be like maybe the school social worker?
Absolutely.
Or
well, in
or
addition,
school psychologist? Or
yes, but also a member of the school district who is able to talk about and commit the school district to services.
Okay, so so like a special education teacher could definitely be there,
Absolutely.
but they may lack the authority necessary to
Correct.
say we're going to do these specific things
Correct.
for you.
Correct.
Okay.
And then at that initial referral / eligibility initial meeting, the school district looks at data, which parents may not always be aware of this, but when your student is in school, there's a lot of data being collected about your student's performance, both compared to his or her progress from the beginning of the year, or progress reports compared to other students in the class. There's teacher feedback, there is support staff feedback, and those items are looked into, and then there's a determination made. Do we think that evaluations should go forward? Okay,
so they're looking at things like maybe like their reading levels.
Correct.
And maybe, when they're old enough and they're doing like multiplication, how fast they can do their times tables, and all those time tests and different things that they do throughout the year, those assessments.
Sure.
Is that some of the data that they're looking at?
Some of the data they're looking at is that, and it's also teacher feedback.
Okay.
Teachers have a good feel for progress that students are making relative to their own potential, relative to other students in the classroom.
So if they see a child that maybe is struggling making friends, or maybe has some anger issues or some impulse issues, those are all kinds of things that they're going to be talking about.
Those are all things that they're talking about.
Okay.
And so at that initial meeting, the determination is made. Do we suspect this is a child with a disability? And if the answer to that question is yes, then the next step is evaluations. If the answer to that question is no, if there is a determination made that no, we don't think this is a child that we suspect is having a disability, there are steps that a parent can take if they disagree with that ultimate determination. Okay,
so I just want to make sure I understand where we're at, because this is a very complicated process.
It is.
So parents or the school, either one, depending on the child and the situation, either the parent or the school can initiate this process.
Yes.
And so letters either from the parent have to go to the school requesting this IEP process be started, or the school will send something home to the parent saying we've started it, and they have 20 days to have the meeting with you.
Well, they won't send a letter that says we have started anything.
Oh.
They will say we suspect that,
Okay.
that there's something going on here,
Mm-hmm.
and once that goes out, then in 20 days they have to have a meeting
Oh,
to
okay.
talk about it.
Okay, and then at that meeting, it's decided whether or not you have enough information and enough instances and data that you're talking about that indicate whether or not they should go forward with the additional testing with the intent that this child probably should have an IEP.
Well, we're not even to the
But
point
we're not
that they
even
should
like guaranteeing
probably.
it. You're just
No.
saying there's a possibility?
There's a
Or that's
possibility.
oh, okay.
The child is potentially, we think this child might be a child with a disability within the meaning
Okay.
of the IDEA. So no formal testing has taken place.
Mm-hmm.
It's all being, everything that's reviewed at that initial meeting that takes place within 20 days of the referral is all historical data.
Okay.
So it's nothing extra that's been done between the initial letter,
Okay.
whether it came from the school or whether it came from the
Right.
parent to that meeting. It's just, let's take a snapshot of this child and do we think that we need to look into it a little bit more?
Right.
And if we think we need to look into it a little bit more, then they'll take the next step. Now there is an interesting sidetrack to that, which is perhaps a child is struggling and but not quite seeing a potential for a disability within
Right.
the meaning of the statute, because the statute sets forth there's 13 statutory categories of disability.
Wow, that's a lot.
It's a lot. It's a lot, and we can go through them if you want. But you could also just look it up in the statute.
Okay.
Some of them are there's auditorily impaired. There's multiply disabled, which is basically if you present with more than one of the statutorily identified disabilities. So a segue or a side note to a decision at that initial eligibility conference that maybe this child, we don't think that this child presents with a disability right now. There's also something called, and you may have heard this, called INRS, and that's Intervention and
Okay.
Related Services. So perhaps there's a student struggling in math, and maybe the kid is just struggling in math. So let's have interventional and related services come in,
Okay.
and or INRS, and it's basically support. It's additional academic support.
Okay.
Not in the form of an IEP, not in the form of a 504. It's offered to every student who is struggling, depending on your district. It may look different depending on the district.
Okay.
But it's additional academic support that perhaps the child might just need a bridge for a short period of time. Perhaps the content is too much for the student at that
Okay.
time. And then they'll revisit with the INRS staff.
Okay.
And so that's a nice additional element that's available through school districts. And then it may be that the student catches back up, or maybe was having a tough time at home, or whatever it could have been, but it was almost like a temporary episode.
Okay.
And so that is kind of the easiest way to describe INRS is a district may want to explore INRS before starting the formal process to see if, with additional support, the child can get caught back up.
Right. So that's more for like kiddos who might be, just not a really strong learner in
Correct.
math or in language arts or whatever the subject might be, and they just need that little bit of help to get them caught back up.
Exactly, because
Okay.
not every academic struggle is
Right.
necessarily related to
Right.
to a disability within the meaning of the statute.
Yeah.
It may just be an academic struggle.
Okay. Now, when you were talking about those categories
Yes.
that people can that students can qualify for an IEP under, is that what they're talking about when they say that we're going to classify somebody?
Yes.
Does that have anything to do with those categories? What does that mean?
Absolutely. Because one of the requirements in order to be eligible to obtain an IEP through the IDEA is to be a student with a disability. And a student with a disability is a student who falls into one of the statutorily defined categories of disability.
Okay.
Which disability, back to what we were talking about in the beginning, creates an adverse educational impact, which requires the student to be in need of special education and related services. So classification, and years ago, I think that word had some negative connotation for some reason, or there used to be, and I'd love to hear your thoughts on that. There used to be some pushback to or reticence with having your child classified.
Right.
And really, it's all that means is that we're trying to allow everyone in the team who is assembling these services to help your child progress and to help your child obtain a free and appropriate education in the least restrictive environment. And it's trying to educate everybody on board as to what that child's struggles are.
Okay. Yeah, I think for myself, definitely in the beginning, it was a real struggle for me to accept these labels that the school wanted to put on my child and that doctors wanted to put on my child, because I know my child, and my child is so much more than autism.
Yes.
And so much more than ADHD or these different diagnoses and these different labels, because you see them, you know, this is a bright, funny, imaginative child, and when you say autism, people automatically think of like one thing.
Right.
And my child is so much more than that. And for me, that, at least I can speak about myself, that would be where my resistance to wanting the classification. And then, you know, and other people see that too, and they'll say, oh, autism, you know, and there's some stigma attached to that, you know, some negative feelings and impressions that people may have, and that can sometimes be really difficult to deal with.
I agree, but remember, these documents are all confidential.
Oh, okay.
So there's another acronym out there called FERPA, which is the Federal Education Records Privilege Act. I think that's what it's called, because I'm so used to just calling it FERPA that I'm not sure that I remember what it means anymore.
Okay.
Federal student records, they're privileged. They're confidential from disclosure. Unless you are a particular defined person within the meaning of the statute. I mean, that's a whole other...
So they're not going to be like gossiping about my child, you know, with their friends, or they're not going to be talking about them. They have, you know, privacy regulations just like your doctor's office or any other place that you go to where you're giving the confidential information.
There are federal privacy laws, which is called FERPA, and then there's also what's called the Pupil Records Privilege here in New Jersey, and that is the New Jersey counterpart, the state counterpart to the federal statute. All of which, in a nutshell, means that student records are confidential and they're not distributed. They're not accessible by the public.
Right.
They're yours and your students alone.
Okay, so basically then if I want somebody to know, I can tell them.
Correct.
But the school would have to come back to me for permission if there's somebody they needed to talk to?
Well, it depends. That information can be shared within the school and some other statutorily defined people. That is, again, a whole other little seminar. But what the confidentiality means is that those records are not available for public disclosure. It's almost, if somebody in the school needs to know because it's the student's teacher or guidance counselor, then that information can be shared. But if I went to the school and said I'd like Jennifer Array's students' records, the answer's no.
Okay, that's good to know. You know, really, because, you know, I know it's a concern definitely for some folks that, you know, and for myself, that, you know, who is going to know this information? You know, this is very private. And personally, I'm actually very public about it, but I know for a lot of people, this is something that they just don't want everybody to know. So that's good to know. They have some rights and protections in place for that. Okay, so let's get back to talking about that classification meeting, that initial 20-day meeting where they decide whether they're going to move forward and investigate the possibility of an IEP. Could they also determine at that meeting whether or not they would rather go with a 504?
They could, and it would depend on the school districts. Some school districts will determine, well, we're really not seeing the adverse educational impact, so we'll set you up with our 504 committee.
Okay.
Technically, there needs to be a separate written request for that.
Okay.
But as a practical matter, sometimes that can all be handled at the same time, not at the same meeting, because there are different people that are involved, but the process could still flow from there.
Okay.
If that makes sense.
Yeah, I think it does. So, all right. So we're deciding that we're going to go forward with investigating the possibility of the IEP.
There's one thing I want to mention, though,
okay,
and that is if the school decides at that initial meeting, no, we do not think that this child has the potential of being a child with a disability. If they decide not to evaluate, and you disagree with that, the school will, you can disagree with that and file for what's called mediation or due process.
Okay.
And we can talk about that later, probably after we get to the end.
Okay.
Because I think that might make better sense. But you as a parent have rights if you disagree with that initial determination.
Right.
And that recourse is to move for mediation or due process.
Okay.
Let's say they decide to do the initial evaluations. And how I refer to it is basically the school will do what I call in-house evaluations, and they will have district staff perform evaluations.
Okay.
At least 2 assessments by members of the child study team. So as we talked about earlier, that's going to be that could be the school psychologist. That's going to be any other member of the the child study team, or the CST, which you'll see that acronym come up a lot as well.
Okay.
2 evaluations, at least 2. They might do a social skills evaluation. It depends on how the child presents, quite frankly.
Okay.
But again, the important thing to remember that at this stage, the first round of evaluations are in-house evaluations. They're done by district personnel. And once those evaluations are done, the team of which the parents are a part reconvenes to review those evaluations. There's time frames attendant to when evaluations need to be done.
Okay. So this process can't take years.
This process cannot take years. The process has to be wrapped up, meaning evaluations wrapped up within 90 days from the date of from the date that the parents consented to have the child evaluated.
Okay.
So
so they complete the evaluations within those 90 days. Does the meeting to discuss those evaluations, does that have to happen within those 90 days as well?
The meeting has to occur within that 90 days.
Okay.
The IEP meeting, or the meeting at which it is determined whether the student is in need of an IEP, must occur within 90 days of the date that the parents signed written consent for the child to be evaluated.
Okay.
So now we're at the stage that initial evaluations have been completed.
Okay.
And the school district is supposed to provide the copies of the reports 10 days prior to the meeting, or at least 10 days prior, I believe.
Okay. So as a parent, I can take a look at those evaluations and try to decipher them, because sometimes I'm assuming they're going to be written with like jargon and terms and numbers that I'm going to take a look at as a layperson and be like, I have no idea what this means.
That's right, because you as a layperson are reading, it could be the school psychologist does a psychological evaluation. There could be PT evaluations, there could be OT evaluations, social worker evaluations, all of which may contain language that as a layperson you just quite don't know what they're talking about.
Yeah.
As it turns out, parents, and I don't know what your experience was, but the evaluations aren't always provided prior to the meeting.
Yeah.
You kind of get them when you show up.
That can be difficult.
And that's difficult because now you're trying to digest a document that you might not quite understand.
Okay.
At that meeting, then the decision is made yes, we are going to, yes, we believe that this child it presents as a child with a disability, there's adverse educational impact, let's put an IEP in place. That's obviously, it would be the preferable course if that's what your objective was in the beginning.
Right.
The decision or the determination could also be made that based on those reports, the school district does not believe that the child meets the qualifications of the statute and therefore is not eligible for an IEP.
Okay.
And what's important at that stage is that as a parent, you have the right to disagree with that conclusion based on the district's in-house evaluations, and you have the right to ask for what's called IEEs, which are independent evaluations.
IEEs?
IEEs.
Oh my goodness.
So an IEE is an independent evaluation done by a third party, not affiliated with the district, at no cost to the parent, to conduct further evaluations of your child.
So you're telling me that with my youngest son, we actually had to have additional testing because we were getting a lot of pushback from the school.
Right.
And I actually contracted with another company, with a doctor's office, to do additional psychological testing on my son. And I could have gotten that paid for by the school?
Yes, you could.
Oh my gosh.
You can always do it on your own dime.
Yeah.
Always, always, always. There's no limitations. You can always do that on your own dime, and then send it to the school and say, I want you to look at this, and based on this, I think my kid, needs an IEP, and
right.
we need to investigate further. You can also ask it to be done at no cost to you through this process. That the district can refuse or say, we do not agree. But in that event, that the district says, no, we don't agree, then the burden is on the district to establish that their decision not to proceed further was consistent and in accordance with the statute. So by doing that, it's taking the burden off the parent to, from a procedural sense, and requiring the district to actually file what's called a due process petition with the Office of Administrative Law to affirmatively establish that their decision not to proceed to independent evaluations was appropriate.
Okay.
So they have to prove they were right. They carry the burden. You as the parent don't have to prove that they were wrong.
Okay. All right.
Which is a big deal. It's a big deal as a parent because it takes a lot of the burden off of you. You are still involved in that process.
Okay.
But the burden is on the district to affirmatively establish that their decision not to proceed further was appropriate.
Okay, and that office that they have to file that with, I'm assuming is part of the state.
It is. So that's called the OAL, which is the Office of Administrative Law. And basically, special education disputes are handled administratively as opposed through the Superior Court that you would go to if you got called for jury duty or something like that. And the Office of Administrative Law is an arm of the state, and it is staffed by ALJs, which are administrative law judges, and it's an administrative agency. So they're judges, but it's not the same as the court that you go to if you got called for jury duty. Basically.
So, all right. So then now you're gone through the process. You've done all the testing, and you've had your 90-day meeting with the school to get the results.
Right.
And we've talked about what happens if you don't agree with those results. But what if they come back and they say, yes, we do agree your child needs an IEP. What happens after that?
So what happens after that is that an IEP is drafted.
Okay.
Typically, it's already been drafted, and it's being tweaked at the 90-day meeting. And it has a lot of requirements. There's a lot of requirements in an IEP, and going back to what I said previously, the IEP is really is the plan. It is the map that outlines what is being done for this child to allow that child to reach his free and appropriate education in the least restrictive environment.
Okay.
And it will outline the child's strengths, the child's weaknesses, what the evaluation said, and then it will go into what's called, this is a weird acronym, it's PLAF. It's the present levels of academic achievement and functional performance.
Okay.
And what that is where is the child presently academically working? What is the child's functional performance? What can we expect from this child in terms of his or her abilities?
Okay.
And then how are we going to set goals and objectives to allow that child to make meaningful progress? And so now that takes us back to what free and appropriate education looks like, which is making meaningful progress in the least restrictive environment. And those goals and objectives are very important. They often get overlooked in the IEP planning and development stage, but they should be goals and objectives that are meaningful, that you can understand as a parent,
Right.
and that you can look at and be able to assess the progress your child is making. It shouldn't just say, and this is the easiest example to give, that Mary will learn to read 10 words. That doesn't tell you as a parent when, that doesn't tell you in what in what speed, this doesn't tell you by week 1, by week 2, by month 1, by term 1. There needs to be an ability to track the progress that child makes from the beginning of the IEP's implementation to the time that it comes up for review.
Okay, and then that totally makes sense. And so now after this whole long process that we've gone through with all this testing and the 90 days and we're sitting at this meeting, it all cycles back around to that whole concept that we started with in the beginning of FAPE.
Correct.
And all this supports that we're talking about at the IEP meeting is to kind of balance the scales for your child, to put them on a more level playing field with their peers so they can learn to the best of their abilities.
It's allowing that each child to make meaningful progress based upon his or her strengths or weaknesses.
Okay.
So it all goes back to your child's progress may look different from my child's progress, but everybody's making progress. And how are we going to identify what that progress is? That's the goal. Our goal is X amount of progress, and how are we going to get that child to make that progress?
Right.
And those are the services that are put in place to help that child achieve that progress.
Okay. Now I know there's a lot of different processes that you can go through to appeal, and you can have people come in and actually like sit with you during this process. You could have experts, you can have legal assistance and things like that. But one thing I want to mention is a pretty big concept, because I myself have sat through many child study team meetings and IEP review meetings, and they're really big on trying to get you to sign stuff right then and there. But there's more to it than that. So what are my rights as a parent to tell the child study team, hey, wait a minute, you're throwing all these, results from this testing at me. It's really confusing. And now you're having me read an IEP that I've never even seen before.
Right.
And now you want me to sign it so that it can be enforced and go into effect immediately. What are my rights during that meeting where I can say, hey, wait a minute, I need a couple, like some time here to process this and understand it and know what's best for my child?
Absolutely. The easiest rule of thumb to remember is you don't have to sign it that day. You have 15 days.
Okay.
And basically what happens at the expiration of 15 days, the IEP takes effect unless you take steps to contest it. And that looks a lot of different ways. You might be able to work with the district and say, I don't agree with this.
Okay.
And let's try and tweak it a little bit more. I don't like this, I don't like that. But ultimately, you can leave that room not having signed the IEP, and you can think about it. You can have somebody look at it. There's a lot of different things that you can do with that 15 days. And if you ultimately do not agree and the district is not willing, or you're unable to reach an agreement as to how to modify it or tweak it in any way, then that's when you would pursue additional legal remedies, which would be through the administrative process.
Right.
Now, there's a little bit of a distinction there, and I want to make this critical distinction. If we're not at the initial stage, so let's say, for example, your child is already a child followed by an IEP, and they're reviewed annually with your school district, and then every 3 years they are reevaluated, and that every 3 years is reevaluating to determine if your child is still a child, a qualified student with a disability within the meaning of the Act, as opposed to, is this IEP working in terms of goals and objectives, and what's the progress looking like from year to year. If you have an IEP in place, and at a subsequent annual review meeting, the IEP is changed in some way that you as a parent disagree with, then that 15 days becomes very important, because if you pursue your administrative remedies within that 15 days, then the effect of doing so basically puts the new proposed IEP on hold and invokes what's called stay put. And stay put means the last mutually agreed upon IEP maintains in full force and effect until the disagreement about the new IEP gets worked out.
So that could be really important.
Very important.
Yeah, that can be huge if the school's looking to take away services that you are contesting, that you are disagreeing with, and saying these services are what's making my child succeed.
Exactly.
And if you take them away, then it's going to deny them their FAPE, their free.
A perfect example is an experience I had with a client who the proposed IEP was going to dramatically change their child's placement from one class to actually to another school. And we were unable to resolve the disagreement. We filed for due process, and by doing so invoked the stay put provision, because we filed for due process within the 15 days following that IEP annual review meeting. And by doing so, the transfer could not occur. The prior IEP, the last mutually agreed upon IEP, which was at School A, had to stay in full force and effect until the new IEP disagreement was resolved. So there's some real teeth there for a parent who has a child followed by an IEP and has some concerns or disagreements with any changes that are made to a subsequent IEP.
Okay, great. And I know we're starting to run out of time, but I really want to just really quickly, I know that as a parent, I have the right to bring people with me. So if I have any legal concerns, or I need an advocate, or I need an attorney with me, I can absolutely bring you and loop you in at any stage of this and say, I need some help. Can you, kind of be in my corner, sit at these meetings with me, and help protect my child's rights?
You're absolutely right. The statute specifically provides that you as a parent, who are an essential part of the team that is assembled to implement or decide how this IEP process is going to look for your child. The statute specifically allows for a person who can basically bring anything to the table about the child, or assist the parents in some way. And that can be an advocate, that can be a special, that can be an attorney, that could be if your child has a tutor who can offer some insight as to the manner in which your child learns. It could be a private therapist, anyone who has some connection, some touch to the child, that can offer something meaningful in the meeting is entitled to be there. And one other thing, if you also have the right to record the IEP meeting.
Oh, you do?
But you have to provide the school with written notice that you're doing so.
Okay.
So that's just a little technical requirement. So in other words, if you did not advise them of that ahead of time, the district could say, well, you didn't provide us with sufficient notice within the meaning of the statute, so therefore you're not allowed to record it.
Okay. Okay.
But it's always something good to know. Some people like to be able to, and recording is not just for lawyerly purposes. Sometimes
it's hard to take notes.
It's hard to take notes. There's a lot of information going on, and you may want to have the ability to go back and re-listen to what the various people who are assembled at that meeting are saying about either an evaluation they conducted or observations they made in the classroom.
Okay, well, good to know. Well, thank you so much,
Thank
Diana.
you.
It's been a real pleasure sitting with you and talking about this overwhelming and very confusing process. And I really appreciate you taking the time to kind of lay it out for us, and really it helped me understand it. Even as a parent who goes through this process every year with my children, there's so much still to learn, and I appreciate the time. And so thank you.
Very much. Thank you for having me.
Yeah, it's been a pleasure.